The City Prosecutor Office of Davao, City Prosecutor Office of Davao. Our speaker is the Chief City Prosecutor of Davao City and the Director for Region 11 Prosecutors League of the Philippines. And he was the former City Administrator of Davao City. Ladies and gentlemen, our plenary speaker number 8 is Prosecutor Nestor Ledesma. A round of applause.
Ibigyan mo lang ito. Ay, ayun na, magsugod naman siya.
So, pleasant afternoon to all of you. It's a pleasure and privilege to be a part of the first international conference on inmates transformative education for successful entry. And my sincerest gratitude to Dr. Alan and myself, President of CPI, and very good friend, Vice President of CPI, Mrs. San Ariaga, and Dr. Lourdes Iniwalao of the University of Southeastern Philippines for inviting me. I am the Chief City Prosecutor of Davao City. So before I give my comments or observation to this very beautiful program of adult education behind us, please allow me this opportunity to apprise you also of the role of the public prosecutors in our criminal justice system. The public prosecutor is the lawyer or the legal counsel or the legal representative of the state. So when a criminal case is filed in court, it will be entitled People of the Philippines versus the accused, the accused. So our client is the people of the Philippines. So as public prosecutor, we protect not the interest of the private complainant, but the interest of the state. The private complainant there is actually only a witness for the people of the Philippines. Our primary function is to secure justice. It is not our primary goal to get a conviction at all costs. Just to illustrate, about 2 or 3 years ago, the authorities arrested a person somewhere in Cotabato in connection with the bombing of the bus terminal in Davao City. So the authorities said that this was the accused in the criminal case who was initially arrested but later absconded. So the suspect or the person in interest was brought to Davao City and held for trial. But the public prosecutor, upon scrutinizing the documents and analyzing the evidence, including the pictures, the fingerprints, and the other evidence in their possession, there because there were 3 of them, realized that it was a case of mistaken identity. They arrested the wrong guy. It was not the accused in the case. So we agreed to the immediate dismissal of the case and for the release of the accused from detention. As I said, our client is the people of the Philippines. And we cannot give justice to the victims. We cannot give justice to the people of the Philippines if we send an innocent person to jail. We are prosecutors, but we are not persecutors. A little about procedure. The procedure is that the police authorities will bring the arrested person to our office, to the prosecutor's office, not to the courts, so that it will be the prosecutors who will decide whether to dismiss the case right then and there in our office, or if there is a probable cause, we file it in court. So we have a wide range of discretion. We can dismiss it immediately. In the case, we never get to court. And we also decide what crime or what to charge and how many to charge. We can charge only one of the accused, two of the accused, or all five of them for a conspiracy. Now, as you know, our criminal justice system is supported by 5 pillars. We have the community, the law enforcement, the prosecution, the courts, and the corrections. Now, the 5 pillars are, of course, interwoven. They are interconnected, and each one playing a vital role upon which the success or failure the other pillars rest. So the efficacy or the effectivity of the entire criminal justice system depends on the successful delivery of the function of each pillar. As I said, if one of the pillars fails to do or perform its function, the entire criminal justice system fails. I believe that each pillar is properly represented in this conference. So in this slide, I will only give a general discussion with respect to the other pillars, just to show their interconnection with the prosecution pillar's function. We start with the community pillar. It is not only the beneficiaries of the justice system in the form of a peaceful, secure, and carefree environment, but it also plays a critical role in holding the other 4 pillars accountable. Further, the community pillar can deter or prevent the emergence of criminals by engaging in programs that divert criminal tendencies towards something more productive. And if criminality does occur, the community must do its part. The community must be a witness to such an occurrence, and later take the witness stand in court in the prosecution of the case. The next pillar is the law enforcement pillar. This consists of the Philippine National Police, the PDEA or the Philippine Drug Enforcement Authority, the NBI or the National Bureau of Investigation, the Armed Forces of the Philippines, and many others. Now, this pillar, the law enforcement pillar, is actually at the forefront of the criminal justice system. Why? They are the first to respond in cases of criminality, and they are the ones directly involved in community interaction. For example, case build-up, interview of witnesses, evidence gathering, and of course, the arrest of the suspects, or the so-called persons of interest. Ideally, we had a lecturer from the U.S. Department of Justice recently, and he said that in the United States, there is really a close coordination between the law enforcement and the prosecution. Ideally, I would say that there should be a close coordination and collaboration between the law enforcement and the prosecution, because this will ensure a higher success rate or a higher conviction rate in court. Remember that the prosecution of cases in court rests primarily on the evidence gathered by the police. If the police, for example, obtains evidence which is not in accordance with the law or the Constitution. Let's say, for example, evidence which is the result of an illegal arrest or a reasonable search, or in a dangerous drugs case, the violation of the chain of custody rule, we cannot convict the accused in court. As a matter of fact, the evidence being the fruit of the poison tree will be not accepted or excluded by the court. Now comes next is the prosecution pillar. That's our pillar. We belong to the National Prosecution Service, or the NPS, which is under the Department of Justice. Other member of the prosecution pillar would be the Ombudsman, but the Ombudsman handles criminal complaints and administrative complaints against public officers and employees. Let me just tell you some of the functions of the prosecutor. We conduct the preliminary investigation or an inquest investigation. Preliminary, that's the regular investigation. We are given 60 days to resolve. We give the respondent time to file his answer or counter affidavit within 10 days. However, if you are arrested, say as a result of a bypass operation of the police, you are arrested without a warrant and you are brought to the office of the city prosecutor for inquest proceedings. The summary in this investigation is going to be summary. We only have 36 hours to resolve the case. We do not give you time anymore. We do not give the accused or the respondent time to file his counter affidavit or his answer to our office. So we resolve the case on the basis of the affidavit of the police, the witnesses of the police, and the evidence of the police. So almost all of this, we will file the case in court. After conducting the investigation, then we charge the suspects in court. That is, if we do not dismiss the case. We are only concerned with probable cause in the fiscal's office. We are not concerned with proof beyond reasonable doubt. When we charge the suspect or when we file the criminal information in court, this now initiates the judicial process and brings into the picture the other pillar of the criminal justice system, which is the courts or the judiciary. And then, the third function is we prosecute the criminal cases in court by presenting evidence against the accused and presenting witnesses against the accused to prove the guilt beyond reasonable doubt. I must say that the job of the prosecutor is a difficult and dangerous one. Many of our colleagues have been murdered and killed. As a matter of fact, last Friday, May 11, our deputy city prosecutor, senior prosecutor from Quezon City, was ambushed on his way home, and he succumbed to 12 bullet wounds to the face, to the head, and to the different parts of the body. I have a very good friend in the fraternity who was a city prosecutor of Mati City. He was also murdered in connection with the job. Of course, in the case of the Quezon City Deputy City Prosecutor Roger Velasco, the NBI and the police are now conducting parallel investigations. But the community must witness. The community must disclose to the authorities what they saw and what they witnessed so that the perpetrators of the crime may be arrested and the proper or the appropriate cases may be filed against them in court. Then, the last function, for purposes of our discussion, may be relevant. One of the prosecutor's functions is to enter into a plea bargaining. This is the process of negotiation between two parties you say the prosecution and the accused. This is akin to a compromise agreement in a civil case. So this means that the accused will bargain or plead the prosecutor for a lower penalty or for a lower offense. For example, the accused is charged with murder, which is punishable with reclusion perpetua or life imprisonment to death. And he will bargain that he will only be penalized for homicide, which is punishable with 12 years and 1 day to 20 years. Or, for example, violation of the dangerous drugs law. You are accused of violating Section 11, possession of dangerous drugs, Public Act number 9165. Penalty is 20 years and 1 day to 20 years. That's illegal possession of dangerous drugs. Now you will enter into a plea bargaining agreement with the prosecution. You will plead guilty instead of Section 11, you'll plead guilty to Section 15, which will entitle you a 6 months rehabilitation in a government setting. In other words, you do not go to jail. You will only undergo 6 months rehabilitation. Now, previously, I do not know if Judge Davao discussed this with you. Previously, plea bargaining is not allowed in drugs cases. So meaning if you are accused of a drug offense, chances are you will not be able to plea bargain to a lower offense. But in the recent landmark case of Estipona versus Lobrigo, decided in the Supreme Court en banc on August 15, 2017, the Supreme Court declared Section 23 of the law as unconstitutional. And henceforth, Supreme Court now allows plea bargaining in drugs cases. This is important because many of our cases are actually drugs cases. Justice Yunen, in his concurring opinion, said, "It is the declared policy of the law to provide effective mechanisms or measures to reintegrate into society individuals who have fallen victims to drug abuse or dangerous drug dependence through sustainable programs of treatment and rehabilitation." The aim is to rehabilitate drug offenders, not to punish them, said the Supreme Court. Now here, the prosecutor plays an important role because under the rules of court, and also as emphasized by the Supreme Court in Estipona versus Lobrigo, there can be no valid plea bargaining agreement without the consent of the prosecutor. That is why it is called agreement, because it is a meeting of the minds between the two parties to the case. And when you speak about the parties to the case, you are referring to the accused and to the prosecution. And the role of the courts is only to approve the moment the accused and the prosecution have already forged or entered into a bargaining agreement. The Supreme Court, in the case of Estipona, said, the defendant has no constitutional right to plea bargain. Plea bargaining is not a demandable right, but depends on the consent of the offended party and the prosecution. In other words, the consent of the prosecution is a condition precedent, meaning it is a prerequisite to a valid plea of guilty to a lesser offense. May I just give you a glimpse of the volume and type of the cases that OCP Davao is handling. The Office of the City Prosecutor of Davao has 35 prosecutors, and we handle approximately 60% of all the criminal cases in filed in Region 11. There are 11 field offices in Region 11, so we handle 60%, so that means the remaining 40% is apportioned among the 10 other field offices in the region. Now, since January 2015 until December 2017, or span of 3 years, our office received approximately 11,676 complaints for preliminary investigation and 8,296 complaints for inquest proceedings, or around 6,657 cases per year. Roughly 50% of our cases under inquest are drugs cases. So we go to the next pillar. The next pillar is the courts. The main task of the court is to hear cases and render judgment in accordance with the law, in accordance with jurisprudence. Now, the last pillar is the corrections pillar. That is comprised of the Bureau of Corrections, the Bureau of Jail Management and Penology, and the prisons administered to the local government unit. Now, admittedly, the role of the prosecution in our criminal justice system ends with the conviction or the acquittal of the accused in court. Our mandate does not really include the creation of programs for the rehabilitation of prisoners. However, we make sure to participate in programs geared towards the rehabilitation of prisoners when invited, such as this conference. Also, we recently participated in a write-up on the development of guidelines in expanding the scope of dangerous drug abuse prevention treatment program to substance use disorder prevention treatment program conducted by the Department of Health. We always endeavor to participate in these programs because we recognize that the criminal justice system does not end in the incarceration of the offenders, but in their successful rehabilitation and reintegration into society. Now, the need for education as a form of correctional rehabilitation. According to the key statistics of the Bureau of Corrections, as of 2017, out of 36,920 sentenced inmates, 1,940 are illiterate. 13,811 have not graduated elementary. 5,431 graduated from elementary. 7,505 reached high school but did not finish. Only 3,981 graduated high school. What does this tell us? This tells us that about 5% of our prison population could not read or write. 57% have not reached secondary school. 77% have not graduated high school. In an incredible 89% have not had the privilege of a college education. Now, on the basis of the statistics from the Bureau of Correction, it is reasonable to conclude that a large majority of our prisoners have been underserved and deprived of the opportunity to complete a formal education prior to their incarceration. Of course, this does not excuse the crimes they have committed, but we ask ourselves the question, would education have made a difference in their life? Delving into what did and did not happen is a futile exercise because it would not change the present circumstance. However, it is crucial to take lessons from the past in moving forward so that we can take corrective actions and do better for the future. Now, further, we're talking about 36,920 inmates. 888 are between the ages of 18 and 21. 21,751 are between the ages of 22 and 39. 12,188 are between the ages of 40 and 59. Only 1,930 are senior citizens like me. So, this means, and at least 61% of them are still at their prime, and they could have been active and productive partners in nation building. So this shows that a large majority of our prison population will be released back to society after service of their sentence. Unfortunately, a failure to rehabilitate them while they are in prison would likely result to an unsuccessful reintegration in society and eventually lead to recidivism and perhaps reincarceration. As we have seen from the statistics, a large majority of our prison population are undereducated and young. Undereducated and young. The reality is, once their sentences have been served, they are released back to the society, they become my neighbors or yours. Therefore, it is important to ensure that they can successfully return to civil life when the time comes. Education should be seen as a form of correctional rehabilitation, available to not only a few, but available to all, or available to the determined and willing prisoner. We all know that education is, it has always been, a great equalizer and a valued asset in the workforce. I was informed that the program College Education Behind Bars now offers 2 courses, Computer Technology and Agri-Business, with about 70 students as pioneering batch. I'm sure that we have already forged memorandum of agreement with the Department of Labor, Employment, probably in Davao, with the Department of Agriculture, in some call centers. I'm sure that you have a dole or dolly coordinator, because the program, College Education Behind Bars, does not end with the graduation of the 70 inmates from their courses or their release from prison. I hope that the program will continue to assist and monitor the graduates after their graduation, because it's difficult. I was president of a little college for more than 10 years. It's difficult to find gainful employment. If you allow the graduates of the college education behind bars to simply fend for themselves and apply for themselves, they might be disappointed, they might be discouraged. So therefore, the program, your coordinator, must monitor and assist them in gaining employment and keeping college education behind bars. So congratulations, University of Southeastern Philippines, the Social Entrepreneurship Technology and Business Institute, and my friends from the Bureau of Jail Management and Technology for delivering a program that can provide life-changing opportunity to our prisoners. It is my deepest and most sincere wish for this program to start a revolution in our correctional system to provide real opportunities for rehabilitation and increase the odds for a successful reintegration of our prisoners to our society as productive and law-abiding citizens. Thank you very much for this opportunity. Again,
Thank you so much, Prosecutor Nestor Ledesma. Okay, so the floor is now open for any queries from our participants regarding the process, regarding the realizations. Now, we can accommodate now questions. Well, we still have more talks tomorrow, and you might like to prepare some in mind that you wish to ask, just in case you haven't yet formed your question and you wish to ask them by tomorrow. Well, let's have that one by tomorrow then. Okay, so if there's no question, okay, so I'm leaving you on 5, 4, 3, no questions really? Okay. So my time is up. At this point, let's give another round of applause to Prosecutor Ledesma. Thank you so much, sir. So let me award the certificate of recognition, or let me read the citation. Davao City Prosecution Office. This certificate of recognition is presented to Prosecutor Nestor Ledesma for delivering an insightful talk as speaker in the first International Conference on Inmates Transformative Education for Successful Re-Entry, signed by the President of USEP, Dr. Ledesma, and Dr. Alan David Meisel, President of SEPI. First day is complete, fulfilling, and very interesting. Just before we cap the day, I know that you would agree that today, especially for those who are not familiar yet with transformative education, these big words are really big, such as recidivism, incarceration. We do not hear this one every day. But for this kind of gathering, of which the advocacy is really special, of course, it's high time for us to be aware and to take what we can share to this kind of advocacy, to this kind of commitment. We have heard about drug abuse, detainees, rehabilitation, the pillar of justice system, imprisonment, but eventually, the latter part of the program, we've heard about transformative education, community-based service, giving second chances, hope, restoration, a possible better tomorrow. So this is all about what this conference is what it's all about. It's about giving hope for those who have been misled, or those who have taken the wrong path, but now would like to take a chance in life. And I would like also to take this chance to thank all of our speakers, our collaborators. Thank you so much, the organizers, SEPI, led by Dr. Alan Meisel, and the Vice President of SEPI, Attorney Susan Carriaga, USEP. Thank you so much. We have a lot of topics set for tomorrow, as well as the presentation of the papers that we accepted for this conference, and those are really interesting. You might like to prepare some questions before coming here tomorrow. As what I have mentioned, let's start our case schedule on time. So tomorrow we will see each other at 8:30 in the morning. Another point that I would like to make clear is that those who have paid on site, please, or those who have paid online, please get your receipts at the secretariat, at the back. One of the committee members of the secretariat. Okay, so If there's no more question or concern for today, all right. So this is a fulfilling day, and enjoy the city lights. For those who are first time here in Davao City, enjoy your stay. And tomorrow will be our second day. And see you all tomorrow. If you have questions again, the Secretary.